Chupin Javier.
Sorry, Judge, I had it on mute. Apologize.
Okay. All right, let's see here. Good morning, gentlemen. Court will resume with the January 26, 2022 docket. And I see Mr. Pena on the screen and Mr. Sanders.
Yes, Your Honor, I apologize. I was also on mute. Good morning, Your Honor.
Okay, no problem. Good morning. Is there anybody else supposed to be coming in? How about Rebecca Vela?
No, Your Honor, I'm handling the hearing for the plaintiffs today.
Okay.
Mr. Rodriguez was going to join, but let me see.
Is that Tony Rodriguez?
Yes, sir. Yes, Your Honor.
Tony Rodriguez. Is he a
Local
party
counsel. Local counsel.
Oh, local counsel. Okay.
Yeah. But I'm fine to. I'm fine to proceed.
I think he's in the waiting room. Let's see if I can bring him in.
Okay.
Tony Rodriguez. All right, he's connecting. I think he connected already.
There we go.
Okay, Mr. Rodriguez, can you hear me?
Yes, sir.
All right, good morning.
Morning, Your Honor.
All right, good morning. I think we're here on, let me see here, CL 19-2120D, Pena versus Rushmore et al.
Yes, Your Honor.
All right. And what do we have here, gentlemen?
Your Honor, we have two motions and special exceptions. One's a motion for entry of a level 3 scheduling order. The other is a motion for designation of responsible third party. And then the third is special exceptions. Mr. Pena filed an objection to the motion for designation of responsible third party this morning, has not filed responses to the other documents. And so if we have an agreement on those, then maybe we could just proceed with the motion for designation of responsible third party. But I don't know what Mr. Pena's position is on those other motions.
Well, on the special exceptions, I think we've pled clearly enough. Texas is a notice pleading state, Your Honor. I think we've pled sufficiently to let them know what they are having to defend themselves against. If they need specifics, a special exception is not the proper vehicle. As long as we meet the notice pleadings requirement, they should be asking us, questions in discovery to find out exactly the specifics. So I do have an issue with that. I do think they have got fair notice under the pleadings.
Okay.
But a response is not required to be filed for that, Your Honor.
Okay. Yes, sir, Mr. Sanders?
Yes, Your Honor. Mr. Pena filed a lawsuit and has conversion, breach of fiduciary duty, fraud, negligent misrep, defamation, fraudulent transfer, conspiracy, money had and received, Theft Liability Act. And if I went through every single claim, we'd be here forever. But the examples are that, Mr. Pena, there's no partnership alleged factually. This is a dispute over insurance proceeds that were received because of a hailstorm. And there's allegations in the pleading regarding a partnership agreement, regarding investments, regarding third-party defendants and third-party plaintiffs. And none of those have anything to do with anything in this lawsuit. And from what I gather, maybe these were left from vestiges from a previous pleading or pulled over from a different lawsuit, but they have nothing to do with this case. And our position is that Mr. Pena should amend those allegations to either say what partnership exists or what investments exist out there, because that's not what this case is about whatsoever. We're not complaining about the causes of action and facts about the insurance proceeds that he claims that were not distributed, or the mortgage or the deed of trust or the note, but we're complaining about allegations that aren't giving us fair notice about what these other facts are that just don't exist to our knowledge.
Well, and the cause of action is not just related to and I understand your concern there. And if we need to clean up, we'll agree to clean up the pleadings, but it's more than that. It's not just suing on the insurance proceeds. The violation in not distributing the insurance proceeds, which Rushmore had nothing to do with, Ditech had nothing to do with. They just took the money and kept it because that's what corporations like to do. But by doing that, not inspecting the property, not repairing the property, which was their duty, a significant and important duty under the mortgage contract, they have violated that mortgage contract. And by doing that under and not remedying that breach within 60 days, under the Texas Constitution, they have lost all rights under that mortgage contract and have therefore have no way to collect under that mortgage contract. They violated their duty, and it is our claim that they now own nothing. Rushmore bought a breached mortgage contract from Ditech, and so they have nothing to enforce.
If I may, Your Honor.
Yes.
Yeah, what Mr. Pena said, I appreciate it, but it actually is completely non-responsive to my points. For example, in Section 7, common law fraud, on page 6 of his petition, he alleges that defendants made a material representation inducing plaintiff to enter into an investment agreement and invest in a partnership. But nowhere in the petition does it allege the existence of a partnership or a partnership agreement or identify any sort of investment that occurred. There's just multiple examples. And like I said, there's also examples of where he refers to third-party defendants, third-party plaintiffs. And again, I'm not complaining about all the allegations he made. I think they're without merit, but all the allegations he made that he just recited, that has nothing to do with our special exceptions. We're entitled to fair notice about who these if there's third parties, who are they? Because there's none in the case. If there's a third-party plaintiff, who are they? We're unaware of them. If there's a partnership, what's the partnership? We're completely unaware of a partnership or an investment agreement. Also, the conspiracy claim alleges a tortious interference claim, but there's actually no underlying tortious interference claim pled in the lawsuit. There's just it's replete with ambiguity and unclarity, uncertainty about what's really going on, and that's all we're asking for him to clean this up.
Okay, and I think Mr. Pena said earlier he would clean something up, right, sir?
Yes, Your Honor.
All right. So let's clean it up a little bit here so we can understand where we're heading or what we're doing here. And then we can get
That's
a better
fine,
grip of what's going on. Okay?
Very well.
All right. Clean up the petition.
Yes, Your Honor.
Okay. And then, yes, Mr. Sanders.
Oh, I'm sorry, Your Honor. And so are we just going to have an order entered that he'll amend, or are you going to grant the special exceptions?
Well, your special exceptions include a lot more than what you're complaining about. I think the judge has ordered me to replead to clean up those. If there are any copy and paste errors, I will clean those up.
You got to clean those up, yeah. So I guess on the special exceptions, I think we won't hold on to them, I guess, until after he cleans it up.
Yeah, Your Honor, that would be great. If he
Let's do that.
Yeah.
Okay, let's do that.
Okay.
Okay,
Very well.
let's do that. And the next matter, Mr. Sanders,
Yes,
which
Your
one?
Honor. Designation of responsible third parties. The motion designate responsible third party. So, as you know, Your Honor, under Texas law, you could designate a responsible third party if the party could be responsible or cause some of the damages that plaintiff's seeking in the lawsuit. In this case, Mr. Pena makes clear that most of his allegations are against the former mortgage servicer that was Green Tree Servicing LLC that later became Ditech Financial LLC.
Okay.
In Mr. Pena's motion for response to motion for summary judgment that were filed, I'm quoting, he said, on or about June 2016, the case against the insurance company was settled. The settlement checks were dispersed. 2 checks for approximately $21,000 was sent to Green Tree Servicing LLC, which later became Ditech. Mr. Pena complains that Ditech didn't conduct an inspection, didn't endorse the insurance checks, and didn't turn over the insurance proceeds to him. And my client, 2 clients, I represent both Rushmore Loan Management LLC, which is mortgage servicer, and Wilmington Savings Fund SSB, DBA Christiana Trust, but as the trustee of the Predium Mortgage Acquisition Trust.
Okay.
The trustee bought the loan on July 25th, 2018. Rushmore became the servicer on August 27th, 2018. Mr. Pena filed his petition on April 16th, 2019, and he had been in an ongoing dispute, clearly, with Ditech, the former mortgage servicer, and many of the complaints that he has are directed at Ditech. And we're taking the position that Ditech's responsible for what Ditech did. If we did anything wrong, which we deny we did, then we're going to have to be responsible for that. But to the extent that there's liability on Ditech, they should be designated as a responsible third party. And Mr. Pena filed an objection this morning, but his objection is really asking you to decide on the merits of the case, who's liable. That's not a proper objection. In order to properly object under the Civil Practice and Remedies Code 33.004, he needs to object and demonstrate that we failed to plead sufficient facts regarding the alleged responsibility of the putative responsible third party to meet the pleading requirement. Okay. And after being granted leave to replead, the defendants failed to offer adequate facts related to the responsibility of the other defendant. It's clear that he has complaints against Ditech. Whether he's saying we're responsible, he's trying to say, hey, in my objection, Mr. Sanders' client's responsible. That's not for you to decide today. That's for you or the jury to decide at the time that it's submitted for purposes of considering liability.
Okay, Mr. Pena?
Yes, Your Honor. I think this is laughable. I think it's says a lot about Mr. Sanders' ability to represent his clients very effectively, even when he's got nothing to stand on. And I congratulate him for that. He's caught in a pickle, and he's asking Your Honor to ignore hundreds of years of Texas law. There's a mortgage contract. It was breached. His client bought that mortgage contract. Usually they buy these on pennies on the dollars. They're just, they're buying debt. They don't really look into it. Well, and sometimes that bites them in the butt, and it did here, Your Honor. They bought a breached mortgage contract that's unenforceable in Texas under the Texas Constitution. He is now saying, well, we bought this. We have the right to stand in the shoes of the previous mortgage holder and enforce this contract, but we don't want to be liable for all of their errors that reached the breach. When they bought this mortgage contract, they stepped in the shoes of Ditech, Greentree, whoever they were back then, for good and for bad. They can't now say that we bought this and we have the power to enforce this, but we want to blame somebody else.
Okay.
They took it over. They are now the mortgage holder. The breaches of the previous mortgage holder relate right to them once they purchased it, unless they bought it with some kind of reservation, which they haven't pled that there are any kind of reservations in their purchase. They made a bad investment, and they're stuck with that bad investment, and they can't complain about who they bought this bad investment from and claim that somehow Ditech or Greentree owes this duty when Rushmore and Willington bought this debt that was already breached, that's unenforceable. Now they're on the hook because they've been continuing these collections actions, continuing to defame myself, and they've been put on notice. This has been litigated before, Your Honor, and this was in our summary judgment response. The previous mortgage holder did try to file a expedited foreclosure under Rule 736. That was denied by 2 different judges, Your Honor. And they were told in the briefings and by the courts back then that this is more than a bad collection case. This isn't a case that's simply someone's not paying their bills.
Okay.
There's a bigger breach that's involved. That was decided in the 275th, and I believe there was one in the 92nd as well. They've tried twice to foreclose, and it didn't work. And they've been on notice since 2016 that they were in breach. Under the Texas Constitution, they have 60 days to remedy that breach, or they lose the right to collect on it. So them bringing in a responsible third party, which they've already stepped in the shoes of, Your Honor, is not proper. This isn't a third party. It's the same party. It's the mortgage holder. They just changed the name of the mortgage holder. So it would not be proper for the court unless they replead. And if they want to replead and somehow allege that they took over and stepped in the shoes of Greentree only for a limited purpose, they need to do that. But they have not pled anything that would give them the right to bring in a third party, because there is no third party.
All right, Mr. Sanders.
Yes, Your Honor. Mr. Pena said there's hundreds of years of Texas case law, but cited not one case to support his position. Texas case law is actually to the contrary. Assignees of contracts are not liable for the acts of their assignors. That is not the law in Texas, unless you assume liability of that entity. And there's a difference whether a loan's void or a prior servicer committed some tort or breach of contract are two separate issues. If the loan is void, yeah, if it's assigned, the loan stays void. Of course, we deny it's void, but that doesn't mean that if Ditech committed some tort toward plaintiff, that all of a sudden my clients become liable for the tort that Ditech committed just because they are the new owners of the loan. Those are two totally separate issues. And I'd be happy to submit some briefing on liability servicers, mortgage servicers, liability of previous servicers, and the general law in Texas is you don't assume liability of an assignor unless you assume that liability. But that's getting really beyond the scope. We've pled sufficient allegations that Mr. Pena, in his pleading, lodged multiple allegations against Green Tree Ditech. Even in his argument, he said back since 2016 they've been in breach. We had nothing to do with the loan in 2016.
And that's important, Your Honor. He's conflating two issues, and I think he's either confused or he's trying to confuse us, Your Honor. He's saying they cannot be held liable for the torts of previous mortgage holders, but what we're complaining about is a breach of contract. It's the same contract. It's a mortgage contract, or actually it's a home equity loan contract.
Okay.
That was breached. Once that's breached, just because someone else buys it doesn't undo that breach. They buy that loan agreement with that breach, and it carries through. This is not a separate tort that we're complaining about. This is the breach of the contract.
Okay, Mr. Rodriguez?
Yeah, but Your Honor, what he's asking you to do is make a determination of that by this objection. That's not the proper way to do it. But
a responsible, we've made the objection, and if you all feel like you all can plead out of that breach of contract, you need to do that based on the pleadings on file now. We're not complaining about that tort and whatever tort you're complaining about.
And you have to make that objection. That's not the objection you made. We're just designating a responsible third party.
We're making the objection. We're making the objection now on the record.
Well,
Your Honor, one thing's really important here. This is not just a breach of contract case. This is a conversion, breach of fiduciary duty, fraud, negligent misrepresentation, defamation, fraudulent transfer, conspiracy, money had and received, Theft Liability Act. He asserts all of those claims, many of which are torts, most of which are torts. And we absolutely pled plenty of facts that Mr. Pena pled to show that he is lodging claims against Ditech, but attempting to hold us liable for them. We pled plenty to do it. And his aspersions against counsel, I'm not sure why he's engaging in that type of conduct, but we've done what we're supposed to do. We've met our burden. And his objection is not, it really lacks merit. And it was filed at 9:24 this morning.
All right, there's no requirement that it be filed before that.
Okay, on this issue,
right as the hearing started.
All right, so then on the motion for leave of a third party, court will go ahead and take that matter under advisement. Anything you want to submit, Mr. Sanders? Any authority or case law? And you too, Mr. Pena. You may do so. I'll give you about a week.
Thank you, Your Honor.
Okay. So then what is it? The third level motion for entry of third level?
Yes, Your Honor. And so we filed the motion for entry of a level 3 scheduler.
Level 3?
Yeah, I got it. I substituted it in July. I think we filed the motions in September. And I'm sure because of COVID and a bunch of other things, we initially had these motions scheduled in November. Now we're hearing them. The dates are probably need to be pushed out further now. I don't know, Mr. Pena, I assume we both still want to do discovery, Mr. Pena. This maybe is something we can agree on. I'm assuming, and I understand that we're not trying cases right now anyway to juries. If Mr. Pena agrees, I would suggest that we submit an agreed scheduling order going forward versus.
Well, Your Honor, I don't have an objection to that in principle, but what I don't want, this case has been going on for a while. There has been some discovery. I don't want to have to go through there's not a whole lot of the discovery that needs to be done in this case. It's a pretty simple case. So if the court wants to set us on a discovery docket, I would just say, let's limit it so it doesn't become abusive. That's my only concern. I don't want it to become abusive.
Well, I've experienced, and I'm not casting aspersions. I've had a difficult time getting a hold of you, Mr. Pena. And so, I mean, I'd like to be able to send a scheduling order and get some sort of response and get it to the court. I'm happy to set a deadline for myself and get it to you. And then maybe, Your Honor, maybe you could set a deadline for us so that we both are ordered to submit something to you agreed by a certain date.
Yeah, and Mr. Sanders, I would suggest instead of sending it just to me, sending it to lead counsel as well, which is Rebecca Vela. That may be one of the problems. Yeah.
Oh,
Okay.
I've never heard anything from her, one word from her, and neither did. Okay, that's fine. If she, I didn't
send
understand she was the counsel. Sorry.
Okay, send it to both, and we'll try to work it out.
Very well.
All right.
Okay, thank you, Your Honor.
Okay, then I think that'll do it. Like I said, in about a week or so, submit anything you want to submit regarding that second motion, and I'll probably have a ruling in 10 days or so.
Thank you, Your Honor.
Thank you.
Very much. You all my big
Thanks so
have a
much.
great day. Thank you.
Take care.
Thank you.
Bye-bye.
Bye.
Bye-bye. Okay, where are we now?
I'm gonna bring in Mr. Daniel Cabrera. He's gonna do all the defaults.
Okay,
Pero we have Mr. Gustavo, which is number 4.
Okay.
Present.
number 4.
And we have Mr. Rodolfo, number 10.
Number 10. 4 and 10, right?
Yes, sir.
I'll tell them about those two.
Yes, sir.
4 and 10. Okay. All right, Mr. Cabrera.
Okay, sorry.
Can you hear me, Your Honor?
Yes, sir. Good morning.
Good morning, Your Honor.
Yes, sir. Thank you for waiting.
No, no problem at all.
It's one of your cases, CL 210106D, Discover Bank versus Gustavo Hernandez.
That's the first one I have, Your Honor.
Oh, okay. I think there's a Gustavo in the waiting room. I think it's him. Let me see if oh no,
Okay.
he's already on the screen there. Gustavo, can you unmute, please?
Yep, here we go.
All right, there you go. You're Gustavo Hernandez?
Yes, sir.
Oh, okay. So this is a case, let's see, this is Discover Bank versus Gustavo Hernandez, CL 210106D. Have you been talking to anybody with Discover Bank trying to work this thing out, Mr. Hernandez?
Well, let me explain. I used to have some of the consolation company that was supposed to be, I was talking to this bank and they couldn't get in a hold or anything like that, or they couldn't get in an agreement. And somehow they say they sent me a letter saying they are supposed to go to court, and they send it to somebody, and somebody got the letter. I didn't, like the hearing or something, I didn't get that letter. And the company I was with supposedly say that they cannot help me because we're going to court or something like that. So yesterday, I was able to drop out for that program and talk to the bank. Yesterday, I talked to them for a little bit, but we couldn't get any agreement. And I told them, well, let me just go to court tomorrow and then see, because they say that no matter what, I had to go to court or go talk to you guys before we do any plan or anything like that.
Okay.
So that's what's going on. Kind of like I told them, I know I owe the money. I got a company that's supposed to be helping me.
Okay, you know what, Mr. Cabrera?
Yes, Your Honor.
Okay, on this one, apparently he was attempting to call, I think, somebody directly with Discover Bank. Do you have a phone number or something that he can talk to and maybe set this?
For Discover, I don't. I have our collections lines for our law firm Zwicker. He can call that line. I do have that number.
Exactly. I talked to them yesterday. I got the number. I talked to them yesterday, and I trying to get a settlement and everything with them. But
Right. Okay. Well, that sounds positive. What we can do here is give you another setting.
Okay.
And we'll take no action on this one. No action.
No action. So it doesn't serve as an answer, the appearance.
Right.
Okay.
It will be abated or something and reset it for what, another matter? Another date?
No action if he needs to reset it.
Okay. No action right now, Mr. Cabrera. If you need us to reset it again, just file something. Okay.
Okay. Can you give us, can you give it, is there any way we can get a date or anything for just the reset?
Yeah. Just submit it in writing. We'll give it a date.
Okay.
And then Mr. Hernandez, just continue calling those people and tell them that we give you an extension of this court matter, and hopefully you can work it out. Okay.
Okay. Sounds good.
If there's another setting, you're gonna get notice. Okay.
Okay. Perfect.
All right. Try to work it out. Okay, sir.
Thank you.
Thank you.
Number 10.
You're excused. Okay.
Hernandez.
Now, Mr. Cabrera,
Yes, Your Honor.
are you also here on? And the reason I ask is I got one more person here. CL 212631D, Goldman Sachs Bank versus Rodolfo Morales.
I think Yes, I am.
Okay, that's the other person I have here on the screen. And I think the only other person. Mr. Morales, can you hear me? You need to unmute, sir.
Yes.
Can you hear me now?
Yes.
Okay. Okay. I heard a cough, but I think you meant to say yes. All right. Mr. Morales, have you been talking to the people regarding the settlement in this matter?
No.
You haven't been talking to anybody?
No.
No contact whatsoever?
No.
Okay. You don't have an attorney?
No.
Okay. What is the amount that is owed here in this case, Mr. Cabrera?
It's $14,379.16.
Okay. Well, then, Mr. Morales, we're set here for default judgment, where the company is, the credit company is seeking a judgment against you, so they can try to collect. After that judgment, once you get it, you can still try to work it out with them. Okay.
Pero how much you got say?
Okay. I think the amount they're seeking is 14,379.
Yes, Your Honor.
14,379.
14 point.
Yeah. 14,379.
Okay.
Okay.
And I need to talk with who?
Well, today is set for judgment. They need a judgment so they can start collecting on it. And once they start collecting on it, see if you can work it out.
Okay.
Okay. Court will take judicial notice of the entire. You still want to proceed with it, Mr. Cabrera?
Yes, Your Honor.
Court will take judicial notice of the entire file in CL 21-2631D, Goldman Sachs Bank USA versus Rodolfo Morales, and you may proceed, sir.
Thank you, Your Honor. This motion for default judgment stems from a breach of contract suit filed July 26, 2021. The defendant was served August 1st, 2021. There's no answer on file. We filed this motion for default judgment September 30th, 2021. In the default judgment packet, there should be an affidavit from our witness for Goldman Sachs dated September 1st, 2021. There should also be a loan agreement copy, a balance transaction copy with the balance statement. There should be an attorney affidavit testifying to the non-military status of Mr. Morales. There should be a certificate of last known address. There's no record on file. And we believe Goldman Sachs is entitled to a judgment of $14,379.16.
All right, court will take judicial notice of the entire file in CL 21-2631D, Goldman Sachs Bank USA versus Rodolfo Morales. Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in his petition. Court will await a default judgment for signature. All right, so then Mr. Morales will get a copy of this default judgment, and then hopefully he can still work out the matter. Okay, sir?
Okay.
All right, you're excused. Thank you very much. And Mr. Cabrera?
Number 5, number 6, number 7, number 8.
All of them,
Number 9.
all of them
They're
his?
all his, yes.
Number 5, my number 5, Mr. Cabrera, CL 21-0584D, American Express National Bank versus Yusuf Akar, aka Yusuf E. Akar. Is
Yes,
that
Your
your
Honor.
case, sir?
Yes, Your Honor.
All right, court will take judicial notice of the entire file, and you may proceed.
Thank you, Your Honor. This motion for summary judgment stems from a breach of contract suit filed February 4th, 2021. The defendant was served February 18th, 2021. The defendant responded with an answer March 4th, 2021. We filed this motion for summary judgment September 1st, July 11th, 2021. We also filed a business record affidavit July 9th, 2021. There should be an expert affidavit dated June 3rd, 2021 in the motion for summary judgment packet. This hearing was scheduled 21 days before it was held, so it's within the Texas Rules of Civil Procedure. The defendant did not file a response to our motion for summary judgment as required by Texas Rules of Civil Procedure 166 AC. We believe American Express has met its burden, and that American Express is entitled to a judgment of $14,353.52.
All right, court will hereby go ahead and grant a motion for summary judgment in favor of plaintiff. Court will grant plaintiff all relief requested hearing this motion, and court will await a judgment for signature.
Yes, Your Honor.
All right, next one here, CL 21-1429D, Discover Bank versus Cesar Peña.
This one, I was wondering, I was looking at we had an agreement with this person and they never gave us back the docs. They never mailed us back. So I was wondering if I could just get that one reset to see if we can give them a
No
shot
action.
to get those
No
docs
action.
back to us.
The orders in here.
Okay, I'll take no action on this one. Submit a new order setting
New setting. Okay.
hearing date. My number 7, CL 21-2035D, Discover Bank versus Pedro Mendoza.
Okay. Yes, Your Honor, I have that one also.
All right, court will take judicial notice of the entire file in CL 21-2035D in the case of Discover Bank versus Pedro J. Mendoza. You may proceed, sir.
Thank you, Your Honor. This motion for default judgment stems from a breach of contract suit filed June 1st, 2021. The defendant was served June 8th, 2021. There's no answer on file. We filed this motion for default judgment August 21st, 2021. In that packet should be an expert affidavit dated July 27, 2021. There should also be a balance statement and the agreement, a copy of the agreement. There should also be a certificate of last known address, an affidavit testifying to the defendant's non-military status. As I said, there's no answer on file. We believe Discover is entitled to a judgment of $6,018, $6,018.76, 5% post-judgment interest, and court costs of $370.15.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in this petition. Court will await a default judgment for signature.
Number 8.
All right, my number 8, CL 21-2181D, Discover Bank versus Annuity R. Perez Sr. Court will take judicial notice of the entire file, and you may proceed, sir.
Thank you, Your Honor. This motion for default judgment stems from a breach of contract suit filed June 15, 2021. The defendant was served June 18, 2021. We filed this motion for summary judgment September 20th, 2021. There should be an affidavit from our witness in the default judgment packet dated August 17, 2021, along with a balance statement, a card member agreement. There should also be an attorney affidavit testifying to the non-military status of the defendant. There should also be a certificate of last known address. As I said, there's no answer on file, so we believe Discover is entitled to a judgment of $15,083, $15,083.96, 5% post-judgment interest, court costs of $374.27.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in this petition. Court will await a default judgment for signature.
Thank you, Your Honor.
You're welcome. And I think the last one here is CL 21-2324D, Discover Bank versus Rosalinda Rodriguez.
Yes, Your Honor.
All right, and for the record, the defendant is not in the waiting room. So court will therefore take judicial notice of the entire file in CL 21-2324D, Discover Bank versus Rosalinda Rodriguez, and you may proceed, sir.
Thank you, Your Honor. This motion for default judgment stems from a breach of contract suit filed June 25th, 2021. The defendant was served through substitute service July 28th, 2021. In the default packet should be an affidavit from our expert witness dated August 30th, 2021, along with a copy of the card member agreement and a balance statement. There should also be an attorney affidavit testifying to the defendant's non-military status and certificate of last known address. There's no answer on file, so we believe Discover is entitled to a judgment of $16,175.81, 5% post-judgment interest, and court costs of $370.15.
All right, court will hereby go ahead and grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in this petition. Court will await a default judgment for signature. Is that it?
That is it, Your Honor, and I will try to get all these orders into you today.
All right, thank you, sir, very much. You may be excused. Have a great day, okay, sir?
Thank you. You too, Your Honor. Thank you.